On the issue of the recommendation for the removal of county executive committee members, I wish to state that the courts of law have on various occasions pronounced itself on the removal of CCs, and the governor, within the law and the amended constitution, sections of the constitution of the County Government Act, has no authority to dismiss the CCs, but only subject to the provisions of Section 40, Section 40 of the County Government Amendment Act 2020, which gives the County Assembly the power to propose a motion requiring the dismissal of a county executive committee member. The only option on this matter then is that this morning I've written to the Assembly to be able to comply by the Section 40 of the Constitution, which requires them to form a select committee leading into the impeachment of the CC, and thereafter then gives the governor powers to remove the CC from the office, because the law says that after the impeachment motion goes successfully, the governor shall comply within 2 days with what the Assembly has given out. So on the matters of dismissal of the CCs, I have returned to the County Assembly of Kericho to be able to follow Section 40 of the Constitution County Government Act and follow that procedure of impeachment, because the committee we had was an ad hoc committee which was looking into the accident, the victims, and all that. But the committee that is mandated by law to impeach the CCs is provided in the Constitution through what we call a select committee of the Assembly that gives powers to the government. The Constitution amended this act so that it gives legitimacy to devolve units and also protect the CECs from malicious attacks, from not acting unfairly, but to give everyone a fair hearing. It is out of this concern then that I returned then the report to the Assembly, asking them to comply with that section and thereafter provide me with their recommendation. Considering also that the office of the chief officer is an office in the county public service as provided for under section 45(2) of the County Government Act 2012, it behoves upon me to forward the names of implicated chief officers to the County Public Service Board to undertake the necessary disciplinary action as per the recommendation of the report and the prevailing law. Basically what I'm saying is that chief officers are employees of the county government employed by the Public Service Board, and they are not subject of directions of anyone else, and their disciplinary action or disciplinary measures upon them is a purview and a preserve of the County Public Service Board, who is the employer. Out of the regulation of the Assembly, I will be forwarding then to the County Public Service, and I've already done it, the names of those chief officers mentioned in the report, so that the County Public Service begin to take disciplinary measures and also give them a hearing, and thereafter provide recommendations to the governor to act on. Because chief officers are not answerable to the County Assembly, but they are answerable to the Public Service Board, who is the employer, because they are public service officers. On the part of the County Secretary, Section 44, 3A, 3B, 3C, and 58A of the County Government Amendment Act 2020 guides on the removal of the County Secretary by the Governor. The 2020 amendment provides for a selection panel to interview and recommend the appointment of the County Secretary and conditions of removal. I will proceed in compliance with the said law to appoint a panel with the approval of the County Assembly to investigate and give recommendations within a period of 10 days from the date of approval. What I mean is that the County Secretary is employed through a panel that interviews them. Removal again of a county secretary is done through a panel. I will then be gazetting a panel as provided by the law that will be able and forward the names of the panel to the assembly for vetting. And when the assembly have vetted the names, then they will begin their work and be able then to investigate into the allegations mentioned, and within a period of 10 days from the date of the approval, be able to give me recommendations on how to proceed.